and this is, return of goods. So any sales transaction with a credit card has been used, or with respect to any sales transaction with a credit card that has been used to obtain credit. So this is you using your credit, right? The credit card user shall credit the amount of the obligor for the amount transaction. Okay. So this is where you would, once you've established and you've stated all the ways they're violating you, in these letters, you kind of have to demand what you want, and you have to use the laws to demand it. So if they've been taking all these remittance coupons and using them as negotiable instruments and turning them to securities, they would be making money off this, while you could have used them to credit your account. So you've been paying, so you've been giving them something extra. So you're going to ask under this, pursuant to this, you want a return of your goods. So this is they violated you. So you're asking, look, the credit card issuer, that's them, they issued you the credit card, shall credit the account of the obligor for the amount of transaction. Why? Well, there's a lot of reasons that I already reviewed, but basically because 18 U.S. Code 8 says that what is the obligation of the United States? All bonds and certificates of indebtedness. It says all coupons, bills. That's all they're obligated to do that. And how do you do that? You do that by using negotiable instruments, to try to get them to pay the debt. So anyway, so on here they said they used obligor, and some people might not know what that means. So what does it mean to be an obligor? The obligor is also known as the debtor. So that's the all caps name. So here when they said the credit card issuer shall credit the account of the obligor, shall credit the account of the all caps name for the amount of the transaction. And here you're asking for a return of goods. So you're asking for some of your money back. Okay, as much. I think you can ask at least for 6 months, but you have to see about that. But I think that's what you can ask for. You can try to ask for more, but I think that's what the law allows. But if you find a law that can ask you can get it all, then go ahead and try to look for it. But you're asking for them to return your past due amount, and they're going to legally give you what they can, unless you find a law to. I don't know if you can give the whole thing back, but I know people have gotten like 6 months back. But anyway, 12 CFR. If this is all about people looking in laws, trying to find things, put affidavits together. I'm going to show you how you started, and then it's like putting these together to make a story to show how they violated you, how they're not. Well, how they violate you, how they're not following the law that's required, and because they're not following that law, they're violating you. That's how this law stuff works. So under 12 CFR 1026.13e, under the billing resolution number 1, you're asking them to correct the billing error and credit the customer's account. See the words it's saying here. These are real things, to credit customer's account with a disputed amount and related finance or other charges. And this is what the procedures are that they have to do. And they have to mail you or deliver a correction notice to the customer. Okay, under 12 CSR 1026.13, this is another rule. The customer's right to withhold disputed amounts. So whatever you're disputing, without, collection action is prohibited. The customer need not pay, and the creditor may not collect any portion of any required payment that the customer believes is related to this dispute. I mean, that is what the law is saying. I'm not saying some companies will look at it and say, okay, and they're honorable and they'll follow the law. And then other ones won't. They will violate you. So when they do violate you, under 15 U.S. Code 1693, and this is either for individual or for class action damages. You're going to try to get for damages, right? Because they failed to comply with some of these laws. So any actual damage sustained by the customer as a result of the failure, I mean, it could be like, you're causing me stress because I can't pay this anymore, and you're violating me, and you did adverse action, like if they try to close your account. Some people will list all the things you did: adverse action, you caused me stress, you closed my account, you gave me late fees, because there's a thing saying that late fees are illegal too. I don't have that law here, but it's just a lot of laws. But these are a lot, like I said, it's taken me a long time to get a lot of these, but there's even more. And I'm just kind of reviewing them so you can kind of get an idea of how the law stuff works. So in here, you're under the civil liability, you're trying to collect for damages here, okay? Because they didn't, some of these are laws. These CFRs are laws. The codes are not. The codes are the violations. So under this law, they have to, with this dispute, they cannot collect. While this is going on, you do not need to pay, and they do not need to, they shouldn't collect. And they shouldn't report anything to collections. So if they don't do this, then they violated you. And then that's when you can say, hey, pursuant to this, we had a dispute. You did this, this, and this. So now, a lot of times they will violate you, like doing the adverse action. And you're not supposed to do that. So that could be a violation. That's a $1,000 violation. Yeah, here it is. You can ask for that. It says 100 or no greater than 1,000. So of course, you can ask. You can say, you closed my account, $1,000. You said something to collection agency, $1,000. You restricted my account, $1,000. Whatever violations you can find, because sometimes they do that. So you have to be willing. If you, like I said, you try it on an account that is not that big of a deal to you, if you want to try it and learn how to do it first. Or you can even open a new account and try to do it with that. Like go spend something and then try to immediately do with that within the 16 days and dispute it and see how it goes. And if you're like, I don't really care about this account, it's not that big of a deal. But you have to be willing to go through the thing. I mean, you do kind of have to care, because you're like, I want to do this, that's why I care. And I'm going to go through the whole thing. So you have to kind of commit to go through the whole thing. I mean, if for some reason you don't, you can always try to just remove it from your credit, because there are a lot of ways to do that. You do have to try a little bit, but you can also do that if it doesn't go well. CFR 1026.13 D3, acceleration of debt and restriction of account prohibited. So they can't, acceleration is like, I'm going to give you these fees, I'm going to give you late fees. So you're getting yourself, they're accelerating your debt. They're getting you more in debt by giving you all these fees and all this stuff. So, and restriction of account is prohibited. So they're not supposed to give you a bunch of fees, and they're not supposed to, and this is a law. So when they do this, they're violating the law. They're not complying with the law. creditor shall not accelerate any part of the consumer's indebtedness or restrict or close the consumer's account. So when they do that, they're breaking the law. And that's when you have a violation. And then that's when you can collect damages. That's how people do it. If you've ever seen them online talking about they violated me. So pursuant to this law, you can say you closed my account. So you violated me and caused me damage to my credit. So now that's a $1,000 fee. I mean, you can take this to court if you want, because that's how this method is, or arbitrate if they don't do it. We'll just report it to like the Better Business Bureau, the CFPB, the FTC, the Attorney General. They'll report it to a whole bunch of people. That's what some people do, and see before they have to go to court or to affidavit. They'll see if they get remedy that way. Anyway, so yesterday I talked about the example of writing it. You have to have your title, your name, the company's name, and address. One thing I didn't mention was it should have a beginning, middle, or an end, kind of like you do in English class when you're writing. So like this, this is kind of like the middle part actually when you're talking. It's kind of like you're telling the story. So it's kind of like, in fact, in accordance with UCC 3306, I, and then you put your name, affiant, am a federally protected consumer, debtor, and a holder in due course. Okay? So you're saying, this is who I am, and then you'd probably say, who are you, who do you have an account with, and then what is going on here, and what do you think happened, how did they violate you, and then what do you want out of this, and how do you want this to continue. You want them to take your coupons, and then at the end you do have to have it notarized, and you put the jurat, Jurat. So that's kind of like saying that you did it in front of a notary, so it was witnessed. And then that, if you do have to, that's only to prepare you if you do have to arbitrate or go to court, then the court looks at that as a witness, and you don't need a person. The notary was your witness. And when you send it certified mail, that's another witness. So anyway, have a good day. Bye.